Long before the first shovel ever hits the dirt, a construction contractor has already done all the heavy lifting. This is a commitment measured in locked-in resources. You've priced a specific work package, appointed subcontractors, and placed non-refundable procurement orders based entirely on the original scope. Then, during the project, a variation instruction arrives. A significant portion of your scope is deleted. The official line from the employer is simple. They no longer require that part of the works for the project. But weeks later, you walk the site and find the truth. The HVAC package removed from your contract is being installed by a competitor. The employer has awarded your exact same scope to another party, leveraging a lower price after your contract was already signed. In the GCC, where standard contracts are routinely rewritten in favor of employers, the common assumption is that you have no legal remedy. Contractors believe that once the standard protections are crossed out, they must simply accept the loss. This perspective is incomplete. Deleting standard clauses changes the legal argument, but it does not grant an employer absolute power to strip your scope for commercial gain. Accepting an amended contract at face value is a commercial trap. It ignores the fact that even without standard FIDIC wording, your rights to the agreed work still exist. To understand how to fight this, we have to look at the historical standard of protection. The 1999 FIDIC Red Book built a specific defense into subclause 13.1 to handle scope reductions fairly. It defines a variation as including the omission of any work, quote, unless it is to be carried out by others. This wording creates a clear boundary. The variation mechanism allows for changes in project requirements, but it prevents the employer from transferring profitable work to a different contractor midstream. In many GCC projects, however, the particular conditions systematically delete this protection. By removing those 6 words, the contract is left to say simply, omission of any work. Employers often go further, scrubbing the provisions that allow you to recover expenditure when a major omission leaves you with unrecovered costs. On paper, this grants the employer significant leverage. They hold the power to reduce the scope at will. For many contractors, this deletion feels like a total loss of leverage. The express FIDIC-based argument they relied on is gone. This is where the strategy must shift. If the contract no longer explicitly protects you, the defense moves from the wording of the clause to the substance of the action. You stop looking at what the text forbids and start preparing to challenge the way the employer is using their contractual power. To do this, we use a standard of evaluation often used by tribunals, the physical reality test. We look past the paperwork to the physical site to answer one question. Did the work vanish from the project, or did it only vanish from your scope? Consider a developer who decides they no longer want a swimming pool in their commercial building. The swimming pool works are deleted completely. The space is left empty. This is a genuine omission. The employer legitimately changed project requirements. Even under a heavily amended contract, this is a defensible use of variation power. Now look at the MEP package. You are the appointed contractor for the HVAC network. The employer omits the package from your contract, but then gives it to a competitor because they offered a better price. This is shopping midstream. This is a disguised transfer. The project still physically requires the HVAC system. The employer is simply using the omission clause as a commercial tool to bypass the original price agreement. A tribunal views this differently than a genuine change in design. They see a project management tool being used as an unauthorized weapon. Regardless of the contract amendments, a tribunal looks for the physical and commercial reality on the ground to determine if the power was misused. Navigating the GCC construction market requires knowing the legal principles that survive even the most aggressive contract amendments. Contractors can leverage established common law precedents like the rulings in Amic Building and Carr versus J.A. Berriman. These cases establish that contractual omission powers must be interpreted according to their original purpose. A contract creates a dual relationship: your duty to perform the work and your right to carry out the agreed scope for commercial benefit. You rely on the full scope to fund corporate overheads and earn the profit margin in your tender price. An employer cannot normally use a variation mechanism to deprive you of that locked-in benefit, unless the contract clearly provides for reallocating the work to others. Common law dictates that these mechanisms cannot be used to achieve an unrelated commercial objective, like shopping for a better price mid-contract. However, most of these projects are governed by local GCC law. This is where we look to the Civil Code, specifically Article 246 of the UAE's Civil Transactions Law. Article 246 requires that a contract must be performed according to its contents and, critically, in good faith. Obligations must be interpreted considering honesty and fairness. Using an omission in an abusive manner to transfer work violates this core statutory principle. This mandate of good faith acts as a hard limit. It prevents the abusive exercise of rights even when the contract wording seems unlimited. Moving from legal theory to administrative action requires a precise set of steps the moment an omission instruction arrives. Your first priority is a thorough audit of the contract amendments. You must identify exactly what was deleted. Look for limitations on loss of profit claims, verify if there are special de-scoping provisions, and map the remaining paths for compensation. The second step is the preservation of evidence. A legal argument is only as strong as the data behind it. You need to prove the exact financial impact of the lost scope. Immediately lock down your tender buildups, pricing assumptions, and overhead calculations. Record your procurement commitments and subcontract agreements. These prove the resources you already deployed before the work was removed. The third step is issuing a formal notice. This notice must do more than just acknowledge the change. It must establish your position early. You must explicitly state whether the work has physically disappeared or has simply been transferred to another party. Explain the financial impact in detail and formally reserve all your rights to seek compensation. This administrative foundation enables formal claims for breach of contract, loss of profit, and abuse of rights. Operating in the GCC means managing contracts that are often weighted against you, but an amended FIDIC contract is not an automatic surrender. A contract is a commercial arrangement protected by the principles of good faith. Enforce the boundaries of physical reality and refuse to let profitable work be transferred by a simple red line.